All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We'll now take up the case of Covington versus the state of Florida. Counsel.
Good morning, and may it please the court. My name is Courtney Hackett, and along with co-counsel, I represent Edward Covington, one of the most profoundly mentally ill people on death row. This case comes before this court on appeal from the circuit court's denial of Mr. Covington's post-conviction motion after an evidentiary hearing was held. Mr. Covington's convictions and death sentences should be vacated because the capital conduct was committed by a man who struggled with serious mental illness his entire life, the full extent of which was neither presented to nor understood by the trial court due to trial counsel's ineffectiveness. We understand
Counsel, you know, I understand that Mr. Covington's got some serious problems, but doesn't the record reflect that most of his problems were the result of abuse of cocaine and alcohol, and that he would engage in behaviors, basically out of control sort of behaviors that were triggered by that abuse, and that he knew it, and that he did it anyway?
Your Honor, that is part of the issue with trial counsel's ineffectiveness in presenting and developing the mitigation. The sentencer's order reflects a completely inaccurate understanding of Mr. Covington's use of cocaine and alcohol. The sentencer characterizes it as voluntary, and while yes, Mr. Covington did ingest those substances, quote unquote, knowing it would cause rage, his alcohol and substance abuse were the product of his mental illness, not an entirely volitional choice.
Help us understand the rule you're asking us to adopt then when someone ingests an illegal substance and it has a mood-altering or behavior-altering effect, and how you propose this court deal with, you know, the voluntary choice of an individual. You said quote unquote voluntary. Help me remove the scare quotes. When are we supposed to say, okay, this wasn't a voluntary act?
Your Honor, had this properly been presented to the sentencer as a product of his mental illness, as polysubstance abuse that was driven by his mental illness rather than an entirely volitional choice, it would have been better understood by the sentencer rather than being used as a non-statutory aggravator to demote the mental health mitigators. And so, Your Honors, what we're asking for is that Mr. Covington's death sentences be vacated because the sentencer's order reflected a misunderstanding of that alcohol and substance abuse. Had Mr. Covington not pled guilty and waived jury, had he not pled guilty, he would have presented an insanity defense, which would not have been negated by the alcohol and cocaine use. There were numerous times throughout his life where he was stabilized when he was receiving the proper medications. However, after failed attempts at getting those medications and getting stabilized, he engaged in self-medication with those substances in an effort to sort of stabilize his own mind when he wasn't receiving the proper mood stabilizers.
Could you elaborate, though? I mean, given what the record shows about what counsel knew from the various experts they had consulted with, I think it was up to 17 possibly, or at least 7 or something, only one of whom would have testified about the defendant having been insane at the time of the crime. I mean, what would the rule be to say that under those circumstances that it's not a reasonable choice for a lawyer who is presenting, obviously, strong mitigating evidence on, the 2 statutory mitigators and all that, but I mean, what would the rule be that we would say that a lawyer faced with that information from the experts had acted, below the level of reasonableness, which, as you know, is a pretty deferential test? I mean, how could we possibly say that didn't rise to, that's effectively the same as not even having had a lawyer?
Well, Your Honor, first, there were 17 or so experts that were consulted by trial counsel. However, not all of them were consulted for an insanity opinion. Not all of them were consulted for the mental health mitigators. The ones who were consulted and did testified to the existence of both statutory mental health mitigators. However, those statutory mitigators were demoted as a result of the sentencer's finding that the drugs and alcohol factored into that.
Didn't the trial judge's order give, I can't remember which label, but it was significant weight to the mitigator, wasn't it?
The sentencer found that Mr. Covington suffered from bipolar disorder and gave that great weight. And with regard to the 2 statutory mitigators, those were given moderate weight. However, trial counsel was operating under a misunderstanding of the law in failing to present the testimony of Dr. Valerie McLean, who was ready and willing to opine that Mr. Covington was insane at the time of the offense.
Well, but the problem with that is you got all these other people that said that it wasn't. So you kind of going down to a path where the refutation is going to come very aggressively and overwhelmingly. Am I wrong?
Your Honor, trial counsel should have at least attempted to present insanity at the time of the offense during the penalty phase.
So counsel, she testified, I believe, at the post-conviction, or it was there, that she was worried about opening the door, correct? I mean, there were 4 state experts that would have testified that he was not insane, and the trial judge had found them credible. So, I mean, what is the likelihood that, well, A, how is that ineffective when there was a clear strategic reason for not putting that on there? And then what would prejudice would have? It seems like it would have been perhaps prejudicial to present that when you had 4 experts willing to say that he wasn't insane.
Trial counsel had significant support from the mental health experts that did testify, again, with regard to the mental health mitigators. Additionally, Dr. Kropp had been on the fence about insanity leading up to the trial. Again, counsel was operating under a misunderstanding of the law with regard to the presentation of insanity, even though it could have, yes, opened the door to the state experts refuting what Dr. McLean stated, given her opinion on insanity. There was substantial other information regarding Mr. Covington's mental health, and the prejudice lies in the fact that the insanity, had it been presented by Dr. McLean, would have lent more support to finding greater weight on the statutory mental health mitigators. There can be no more compelling evidence than that someone is insane at the time of the offense. It's beyond just substantial impairment. Insanity reflects a complete absence of reason, the ability to reason. And so the prejudice lies in the fact that the sentencer did not hear that Mr. Covington was insane, and as a result, those 2 statutory mental health mitigators were demoted in weight. Also factoring into that were the drugs and alcohol, which do not negate insanity. In some cases, they can bolster it. When you're having that interaction between a mental illness to the extent that Mr. Covington was suffering, the lack of stabilization on the medications, the stressors, and the polysubstance abuse, insanity at the time of the offense would have been incredibly mitigating.
In light of the statute that says that voluntary intoxication is not a defense to a criminal act, do you have any cases that say that it is that the finder of fact can find someone to be insane while they are under the influence of substances that they've voluntarily taken?
Your Honor, I believe it is in Code v. State of Florida, 946 Southern 2nd, 988. There was evidence supporting a statutory mitigating circumstance that the defendant was unable to conform his conduct to the requirements of the law, and part of that involved the ingestion of drugs and alcohol.
But that's not a case where the person was found to be not criminally responsible for their acts. So it's not correct?
Correct, Your Honor. But there's nothing saying that it could not have been presented in the sentencing phase.
Are you suggesting that the evidence is such that no reasonable trier of fact could have found counsel's decision to be reasonable trial strategy?
Yes, Your Honor.
Okay.
I believe that evidence of insanity at the time of the offense, if it had been presented during the guilt phase, had a likelihood of success and would have resulted in a finding of not guilty by reason of mental insanity. Instead, counsel neglected to present that during the sentencing phase. So even though Mr. Covington waived all defenses to the guilt phase, he didn't waive the presentation of mitigation or this highly compelling information that he was insane at the time of the offense.
I think you're down to 3 minutes.
So, Your Honors, we are just asking that Mr. Covington's convictions and death sentences be vacated because these horrific facts, if nothing, lend support that these offenses were committed by a man who was seriously mentally disturbed to the extent of insanity. And that information should have been presented to his sentencer. It could have affected the outcome of weighing the aggravators against the mitigators. This is a highly aggravated case. However, it is not the least mitigated case. There is substantial mitigation present. The presentation of insanity at the time of the offense, along with presenting the alcohol and substance abuse as a separate mitigating factor itself, could have altered the weighing of the aggravators and mitigators. Mr. Covington is a member of a class of individuals who is seriously mentally ill. He has reduced culpability. His case is not one that involves a situation where there is no mitigation. Yes, it is truly horrific. However, Mr. Covington he accomplished substantial achievements when he was stabilized. It is not as though he committed horrific offenses his entire life. He suffered a massive psychotic break as the product of his serious mental illness, polydrug interaction, numerous neurodevelopmental complications, which also could have gotten greater weight had those been presented in more of a context. So there was substantial mitigation. Mr. Covington is more than the worst thing he's ever done. And we are asking that you vacate his conviction and sentence of death. And if there are no further questions, I will resolve.
Just to clarify, you've
Yes.
said twice now that you're asking us to vacate the conviction. You're just talking, but the remedy here would just be related to the sentence, right?
Yes, Your Honor, that's correct. And I will reserve the remainder of my time for rebuttal.
Good morning. May it please the court. My name is Marilyn Beckwith and I represent the state of Florida. I'd like to focus the court's attention on the procedural posture of this case. The issue before the court is whether counsel was ineffective in representing Mr. Covington. Mr. Covington had not just effective assistance of counsel, he had exemplary assistance of counsel. He was represented by a team of attorneys who among them had decades of criminal trial experience. Ms. James and Ms. Holt, who is the elected public defender of the 13th Judicial Circuit, had decades of capital litigation experience between them, all facets of capital litigation, trial litigation, appellate litigation, and post-conviction litigation. They were very clear-eyed about the challenges that Mr. Covington's case presented. He was accused of and admitted to the brutal murder of a mother and her 2 young children. He was found hiding in the closet where the dismembered and decapitated body of 2-year-old Heather Savannah was found, where the mutilated body of her brother, 7-year-old Zachary, was found, where the badly beaten and eviscerated body of their mother, Lisa, was found. Even the family dog didn't escape Mr. Covington's violence that day. Duke was found dead, bludgeoned to death in Heather Savannah's bedroom. Nonetheless, over the 6 years that they represented Mr. Covington prior to trial, they fully investigated his mental health issues. They discovered that he had a long-standing mental health disorder, bipolar disorder, that he had intermittent explosive disorder, and he suffered from polysubstance abuse disorders. They consulted with no less than 17 different experts, 7 of which testified at the penalty phase. Of those experts, only one, Dr. McLean, was willing to testify that Mr. Covington was insane at the time of the offense. Nonetheless, they were willing, despite the long odds, to go ahead with an affirmative defense of insanity during the guilt phase of the trial. As this court knows, shortly after the trial commenced, Mr. Covington became agitated. A recess was taken. He had conference with his attorneys. He spoke with his parents. The judge ordered a competency evaluation. The next day, Mr. Covington came in, pled guilty to all of the charges against him, and waived a penalty phase jury. The defense presented 7 of their 17 experts at the penalty phase. They all discussed Mr. Covington's long-standing bipolar disorder, his efforts to obtain help, and how the cocaine and alcohol abuse was a comorbidity of his bipolar disorder. And the sentencing court did find that he suffered from cocaine and alcohol abuse, and he gave that mitigator great weight. He combined it with the bipolar disorder and the intermittent explosive disorder. So he found those mitigators and gave them great weight. This was not a case where there was information that was later discovered during a post-conviction proceeding that was not presented at the penalty phase. The complaint seems to be that Dr. McLean just didn't utter the words insanity. Ms. James and Ms. Holt both testified, number one, they didn't think it was inappropriate to raise an affirmative defense of insanity during the penalty phase. Now, Mr. Covington isn't challenging his plea here, so he's not indicating that for some reason that they should have raised insanity for purposes of challenging his plea. But they did talk about all the same underlying mental health issues and disorders that Mr. Covington has suffered from his entire life to support the mental health mitigation. The judge did find both of those mitigators and gave them moderate weight. Well, let me step back there. He found the inability to conform his conduct to the law was impaired, but not substantially so because of his voluntary use of alcohol and cocaine.
It diminished.
Correct. It was diminished. Now, that was something they weren't going to be able to avoid because Mr. Covington did speak of it during his statement to the police, that how particularly with alcohol, he knew he had a rage reaction. He also talked about throughout his entire life, his moods were kind of like an on and off switch. This was not, although this was a horrific act on Mr. Covington's part, it's not fair to say that he has no history of any kind of violence. The defense knew that he had a history of perpetrating abuse on his sister. He had some other instances with his ex-wife. None of this was focused on at the penalty phase as any kind of aggravator. Instead, it was discussed in relation to his various mental health issues. There was little that was not discussed about Mr. Covington. I agree, he has a history of mental disorders. He has bipolar disorder. He has intermittent explosive disorder. I can't disagree with the court's findings in that regard. They were determined by the court, and they were given weight that the court felt was appropriate.
I'm sorry to interrupt you here, but is it fair to say that the testimony from defense counsel at the post-conviction hearing reflected some maybe confusion or muddled thinking about sort of the difference between insanity as an affirmative defense versus just arguing insanity as a non-statutory mitigator?
I would not agree with that. I think they were very clear on the distinction between an affirmative defense of insanity and the mental health mitigation. They also knew that had Dr. McLean testified at the penalty phase that Mr. Covington was insane, the state would have cross-examined Dr. Rao and Dr. Kropp, both defense experts who were going to testify and did testify at the penalty phase, about their opinions that he was not insane. And of course, the state also had two experts lined up who were going to testify that he was not insane. There were other experts who had the same opinion that Mr. Covington wasn't insane. He was evaluated for competency. He was evaluated after he filed his notice of intent to rely on insanity by Dr. Mayer and Dr. Taylor. They both found that he was not insane. So the post-conviction court found that even if it were an available mitigating circumstance, it was a reasonable tactical decision for the defense to not take that extra step to go to the word insane and rely instead on the substantial mitigation that they did rely on, the mental health mitigation, because they knew that if they had opened that door that the state was going to walk right through it. Now, this case had been litigated for 6 years prior to this all commencing, so there weren't a lot of secrets between the state and the defense. Obviously, they had notified the defense they were going to pursue insanity. He was evaluated by state experts. Information was exchanged. So they were pretty aware of where the state would have went had they tried to introduce insanity. And frankly, it's potentially would have been objected to, but at this point, we don't know because it wasn't introduced at the penalty phase.
Can you maybe tell us?
Sure. The defense did move the court to introduce mental health evidence short of insanity at the guilt phase. So in other words, a diminished capacity type of defense. That was litigated. That was denied. And they, excuse me, obviously did the notice of intent to rely on insanity. Depositions were taken. The state took the depositions of, I believe, I believe Dr. McLean, Dr. Kropp, Dr. Rao, possibly Dr. Saw, who was the doctor who evaluated Mr. Covington at the hospital meeting the day after these events and evaluated him for a Baker Act. I believe the state also took the deposition of, his name escapes me now, but the doctor who had treated Mr. Covington after the incident with his ex-wife and the cat mutilation incident that they had presented as evidence of his history of a longstanding mental health disorder. So it was fairly well litigated throughout the, it was obvious to both the state and the defense where we were going with this case because of the horrific nature of the facts. And Mr. Covington's ingestion of Tylenol, aspirin, and his Seroquel after the fact, that the issue was going to be what his mental status was when he committed these horrific crimes. The sentencing court issued a very lengthy and thoughtful order, understood the distinctions between the mental health disorders and the voluntary use of cocaine and alcohol. This was a very experienced judge who heard all of the evidence. He was not under any misconceptions about the significance of the mental health mitigation that was presented in this case. I don't recall, and I apologize if counsel discussed the antisocial personality disorder issue, but I just wanted to inform the court that this trial judge, as evidence of the fact that he understood the distinctions here, specifically noted in his sentencing order that he was not considering that as an aggravator. He understood that that can't be used as an aggravator, and it was introduced merely to rebut the testimony of the bipolar disorder, which obviously he found existed and gave great weight. I would urge this court to affirm the post-conviction court's order denying post-conviction relief in this case. Unless the court has any other questions, I'll relinquish the podium. Thank you.
Counsel, rebuttal?
Good morning. David Hendry for rebuttal. Insanity is different. This case is very different. I've been arguing before this court for about 20 years now. This is my very first insanity case. It doesn't happen all the time in these cases. Mr. Covington is mad. He is insane. It's elementary that when a man is insane at the time of the offense, you present evidence that he is insane at the time of the offense. There was no waiver here, and that's the crux issue in this case, is did Mr. Covington waive insanity at the time of the offense at the penalty phase? And if you look at that penalty phase, if you look at that plea form, which was exhibit number 20, state's exhibit, it's a very long plea form, and there is absolutely no waiver of insanity at the time of the offense at the penalty phase. So it's not knowing or intelligent at the very least. It is elementary. As a criminal defense attorney, a capital defense attorney who's very experienced, you have to present insanity at the time of the offense because it's not just the two statutory mental health mitigators. It goes way beyond that. It's not that he wasn't playing with a full deck. He didn't have a deck.
Well, but counsel, I mean, I understand your position on this, but there's still the problem of all these experts that say he was not insane. I mean, do you dispute? You shake your head. Do you dispute that the numerous experts said that he was not insane at the time of the offense?
You start with your best foot forward. Dr. Valley McClain.
I asked you a question.
Okay.
Do you dispute that?
3-0. Post-conviction, 3-0. It was unrebutted that he was insane at the time of the offense. We met our burden. We presented Dr. Cunningham, we presented Dr. McClain and Dr. Wood with a PET scan that showed that this man, he has organic brain damage.
What was the count at the time that counsel was making the decision whether to characterize this as insanity, which is that's the relevant point in time, not the experts that you had at the post-conviction hearing. What was the count?
That's a red herring.
No, it isn't. What was the count?
I didn't try this case, but I will tell you this. They had at least one expert who said insane at the time of the offense. And it is disingenuous to say we were going to go to the guilt phase and present insanity at the time of the offense, and then at the penalty phase to say it's not really genuine. We only have one expert. Dr. McClain can't be believed.
So you don't know the count?
The count of...
At the time that counsel was making the decision?
I know that Dr. McClain said insane at the time of the offense. This case was very perplexing because there's absolutely no discussion whatsoever about insanity at the time of the offense in this court's direct appeal opinion. So we had to dig and dig and dig to find that opinion that he was insane at the time of the offense. And again, you start with...
I have to say, I'm kind of disappointed with your candor at this point. I mean, we've talked about it now in the OA. Are you telling me that you don't know what the count was or ballpark. You know that there were other experts who had been consulted at the time that counsel was making this decision.
I know that Dr. McLean opined insane at the time of the offense, and I know that there wasn't a lot of go-between between defense counsel and these mental health experts as to, you have to ask your mental health experts, was he insane at the time of the offense? And going to Justice Lawson's question about the voluntary intoxication, 3.6, there's nothing in the jury instructions that really that say that if you ingest crack cocaine and alcohol, that this negates the insanity defense. Crack cocaine and alcohol would only accelerate insanity at the time of the offense. And, you know, I'm trying to be candid here. All I can say is that we had 3 experts, unrebutted, that said insane at the time of the offense. And open the door, as a criminal defense attorney, it's your job to try to open the door. Here's the question that this court has to ask, okay? Had defense counsel tried to present insanity at the time of the offense, and had the state objected to this evidence, and had the court prohibited this evidence, would this court then reverse that decision? Because under Hitchcock, Eddings, and Lockett, any circumstance of the offense is presentable, is admissible at a penalty phase.
Counsel, you've exhausted your time. I'll give you another 30 seconds to sum up.
Thank you. The very relevant cases here are Hardwick from the 11th Circuit and Kimmelman from the United States Supreme Court, which we cited, which basically say this: defense counsel was operating in this case under a mistake of law. They said it was inappropriate to present insanity at the time of the offense. That is wrong. Because that is wrong, this cannot be a reasonable strategic decision. This is elementary. You have to present insanity at the time of the offense in a capital case when a man's life is at stake. Thank you very much.
Thank you, counsel. We thank you all for your arguments in this case today. The next case on today's docket will be heard remotely. So that concludes this session of court.
All rise.
Just a reminder.
Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this remote session of the Florida Supreme Court. We will now take up the case of Suarez Trucking versus Souders. Counsel?
May it please the court. My name is Kansas Gooden. I represent Suarez Trucking. I like to reserve 4 minutes for rebuttal. A settlement was reached in this case when Suarez Trucking filed a written notice of acceptance in the trial court. Florida statute 76879 states, an offer shall be accepted by filing a written notice of acceptance with the court within 30 days after service. The legislature mandated how a proposal for settlement is accepted. And when a legislature prescribes the mode, that mode must be observed. And it essentially is a prohibition of it being done any other way. And this statute simply requires a written acceptance, nothing more. It doesn't require, despite what the second DCA held, that the parties parrot back each and every term of the proposal for settlement. It simply has to say, I accept.
Also, I'm sorry to interrupt.
Counsel, if I could ask you this, counsel. Now, there's really no suggestion that the parties who wish to settle a case have to operate under this statute. If they just want to settle it and without reference to the statute, they don't get the benefit of the statute, but they are not precluded from doing that. But if they want the benefit of the statute, they have to operate under the statute. Isn't that correct?
100%, Your Honor. And Souders made that deliberate decision here to operate under this statute.
Can I ask you a question? So part of this case has to do with the acceptance issue, but then the other part of it has to do with, even if we agree with you that there was an acceptance of some kind, whether the agreement was breached. And with regard to that second issue, what is the legal significance of the fact that before the acceptance and before sending the check, that apparently counsel for each side communicated directly on this issue of satisfying the lien, and that on the plaintiff side, it was clearly communicated that that was not acceptable, that the check had to be just made out to the plaintiff alone? Does that have any legal relevance here?
No. And if you turn to actually Rule 1.442, it states that oral communications do not constitute a counteroffer. It doesn't constitute a rejection whatsoever. What was happening here is just trying to seek clarification, because the defense was in a catch-22. This was a valid known lien that they just wanted to make sure was taken care of. And if you do look at the record, there were disputed statements regarding exactly what happened. Suarez Trucking takes the position that that conversation was, will you make assurances that this lien will be taken care of? And the plaintiff's attorney at the time said, no, I'm not going to give you assurances. And those assurances came later. The plaintiff's attorney at the hearing, I believe, said, well, this was about a release. They were asking about a release. So there were disputed statements below regarding those conversations. But ultimately, I don't think those disputed statements really go one way or the other, because I think the issue is truly a legal issue. And it kind of goes back. Though?
And so what's the legal issue as you see it on the breach question?
On the breach, kind of what's the remedy? And if you
hold on, before we get to the remedy though, if we read the proposal for settlement and we see where it says the defendants shall pay $500,000 to the plaintiff within 10 days from the date of acceptance, if we read that as on its face requiring payment to the plaintiff and not to anyone else, do you lose?
No.
Okay, why not?
We do not, because the statute controls, and we have a valid settlement agreement. And so that's when we would get remanded for a judgment of $500,000. And then there would be a further determination of whatever this work comp lien is. And the support.
There, I think you face another catch-22, to use a phrase you used. So let's say we agree with you, the statute controls and it should influence, what we think constitutes an acceptance in this case. Don't we then lose jurisdiction because in Marin versus Infinity Auto, the statute wasn't at issue, and it's not a case governed under the same provision, and so. If you're right, then we don't even have a conflict to resolve.
Well, there's two different conflict cases here before the court. The first one is Cirrus Design specifically.
Let's assume for the sake of argument that we don't think there's a conflict with Cirrus. Focus on Marin.
So Marin, I do believe there is a express and direct conflict, even though it's not traveling under the PFS statute. It regards to how, especially whether that lien holder should be required on the check and whether that's an essential term. And if you look at the opinions in both cases, they came out differently. The second DCA said, yes, that was an essential term. The third DCA said it wasn't.
Right, I know, but my question is to the fact that Marin, the statute's not at issue in Marin, right? We agree on that.
Yes.
Okay. So help me out with the catch-22, or are you just sort of admitting that there is, in fact, this like weird catch-22?
There is a weird catch-22, but it's mostly, and it's the mechanics of the lien is how the lien was playing out. And I think the catch-22 is more in the situation of the defense was in a bad situation of knowing whether or not this lien was going to be taken care of. And that's where the Marin case comes into play. Now, I know you said don't take Cirrus into account, but if we do take Cirrus into account, there is conflict jurisdiction. And once this court has jurisdiction, it has authority to address all issues in a case. And that's when you can kind of flow down and deal with the remedy and everything with kind of everything that flows from this.
Counsel, you keep talking about remedy, but now I understand if there was a breach, you think the remedy is to enforce the settlement agreement as opposed to rescind the settlement agreement. Okay, that's your position. But isn't it your basic position that there was not a breach?
Correct. We do not believe there was a breach. And this is just based on the plain language of this proposal for settlement. Because the language says shall pay $500,000 to the plaintiff. And just plain language, that does not say a check shall be made payable to. It doesn't direct how the check.
But doesn't your argument also, I understand you've articulated that, but doesn't your argument really more turn on the fact that part of the backdrop for this whole situation is not just the offer of judgment statute, but the statute that governs workers' compensation liens. The statute that provides that when the plaintiff here brought the lawsuit, that by operation of law, the plaintiff was bringing the lawsuit not only for the plaintiff, but for the use and benefit of the carrier.
Correct,
and
Honor.
all of that, and the law that says that these funds can't be dispersed until the allocation between the carrier and the plaintiff is worked out either by agreement or by determination of court. That's all part of the backdrop for this that informs your argument. Isn't that correct?
That is correct. And if you go back to Circle K.
Can I ask you, I'm sorry, counsel, I'm sorry to interrupt you.
Would you let her answer my question?
Oh, I'm sorry. She did answer your question.
I'm sorry.
If you go back to Circle K, it even says that the work comp carrier has to consent. And the same with Century Elevator talks about how that lien holder actually has to participate in the settlement. And that is all under the guise of the work comp statute.
Justice Moody?
So I'm that on that background law issue, is it your position though that what if it seems like part of your argument here is that you're kind of ignoring the negative implication of, pay me $500,000. And you're saying that on its face, that doesn't preclude the possibility of adding other people to the check. So let's put that aside for 1 minute. But if we have this argument about the supposed background law, what if the settlement had said explicitly write me and only me a check for $500,000. Is it your position that that would be sort of a legally not permissible offer? I mean, help me understand what work you think the background law is doing here.
Well, under that scenario, I still think we would have a settlement agreement. And that's just going back to the plain wording of the statute. The moment that that notice of acceptance was filed, there's a settlement agreement. And that's just plain language of that statute. Where that language comes in that you just referenced comes into how it's enforced. And specifically, that would have to go to, again, the performance of the proposal for settlement at that point. And the 4th DCA has been kind of clear for almost 20 years now that when you're dealing with a situation under the proposal for settlement statute, you don't have to have the ability to pay. If you don't have the ability to pay, what happens is a judgment is entered. And so a judgment for $500,000 should have been entered at that point. It shouldn't have been defined that the acceptance that was filed was null and void. And that's what the trial court did. And that's where the case really went awry at that point.
But doesn't Cirrus itself say, though, that as with any other contract, one of the remedies for a breach of a settlement agreement is rescission? I mean, why should in this context, if you in the scenario that we gave where there's no doubt whatsoever that the offer said, I only want my name on the check, and then that's quote unquote accepted, and then 10 days later the check comes through and it has multiple names on the check. You agree that in that case there's a breach. You're saying that the only remedy is you've got to basically force the entity to write a new check with only one name on it. But I mean, isn't it just basic contract law that the plaintiff would have the option of either that remedy or rescinding the contract? I mean, that's what Cirrus says in the footnote 4.
Correct. Cirrus does say that in footnote 4. However, the parties actually have to plead that. In this case, the parties never pled rescission. Sowers never said, we have a contract, let's rescind it. It was, we never had a contract. And those are two different things. To get to rescission, you have to admit there's a contract, and they never did that here.
So would that then go to, would essentially, and this is part of this whole issue with the jurisdiction, is just speaking for myself, I'm kind of wondering kind of what the point of all this is, because it seems like, you know, I could see us saying, look, there's a conflict on whether there was really an acceptance of a contract, and we're going to resolve that and say that there was an acceptance, but there's no conflict on the sort of breach, and if so, how you remedy issue. If we were to send it back and say, okay, assume there was a contract, now you proceed under that assumption, and then the plaintiff says, we want to rescind, then we're right back in the same place. I mean, I don't know that there's any authority for us to say that rescission at that point would not be an available option, that is just off the table. So could you give me authority that takes that off the table on remand?
Well, on remand, and again, rescission has never been alleged and never been assault by Souders. The fact that it's being brought up now at the Florida Supreme Court, it seems, honestly, it's coming out of left field, because that, again, the remand would have to be what was before this court. And if you look at Cirrus, and if you look at Suarez Trucking, and in Cirrus, they enforced that settlement. And so when you're dealing with a conflict, let's take en banc procedures out of this. When you're dealing with conflict, if you have one case that essentially would be overruling the other case if they were issued by the same court, that's a conflict. And if you read Suarez Trucking, and if you read Cirrus Design, that's what we have here. And so if you accept and approve Cirrus Design, the remedy is enforcing this contract. It is not allowing them a second bite of the apple to try to rescind this contract. It is instead enforcing it.
And counsel, let me ask you about footnote 4. This has been mentioned. It says, although Cirrus does not make the argument the logical extension of Cirrus' position is that rescission of the settlement contract is a possible remedy that plaintiffs may pursue. Whatever that is, isn't it dicta?
100%. It is dicta, and it's the same situation we have here. Souders never pursued rescission. And I think a lot of it has to go with, they never admitted there was a contract in the first instance. From day one, they took the position there was no contract. And so I think that's really, our case is in express and direct conflict with Cirrus Design.
Counsel, though, are you disputing though the premise that the plaintiff, I mean, are you hinging it on this sort of waiver thing? I mean, where obviously they're not going to argue rescission if they're saying there's no contract to begin with. But just to get back to what the chief is asking you, dicta or not, are you disputing the legal premise that the plaintiff would take waiver off the table for a second? In a case, let's say that could they have argued at the beginning, trial court, hey, we think there's no contract, and even if there is, there was a breach and we choose as a remedy rescission. Are you telling me that legally would have not been a permissible request, a valid option for the plaintiff?
The plaintiff could have pled that, and it could have pled that in the alternative. You could have admitted the existence of a contract and not the existence. You're allowed to make alternative arguments, but that never happened here. Okay. And so and again, this is why we are directly in conflict with Cirrus. It was never alleged in this case. It wasn't alleged in Cirrus. Rescission is an option when you're dealing with contract cases, but it has to be alleged. And for now, all of a sudden to be alleged.
Isn't it also true, counsel, that rescission is not always an option for every breach? It depends on the type of contract, and if it's a substituted, there's certainly, isn't there authority that if it's a substituted contract, that there are at least some circumstances where rescission is not available for every breach?
I believe so, Your Honor.
All right, counsel, I have helped you use that part of your rebuttal time. You can keep going, but you're using it.
I'll reserve the rest of my time. Thank you, Your Honor.
Thank you. Counsel.
Good morning. May it please the court. My name is Joel Eaton, and I represent the respondent, who is the plaintiff below, Adam Sowers. I would like to begin by establishing three undebatable propositions of the law of contracts here. It'll be very brief. Assume this offer was made prior to filing suit. It plainly would have been an offer to enter into a unilateral contract. A unilateral contract can only be accepted by performance, and the performance.
I understand you want to repeat your tutorial on the law of contract for us here. We appreciate having the benefit of that. We're much obliged for it in the brief. But let me ask you this: when I look at what actually happened here, not some hypothetical, it seems that the actual offer that was made invited a promissory acceptance. Why am I wrong about that?
I'm reluctant, Mr. Chief Justice, to say you're wrong about anything, but there is an answer to your question. The offer that was made was not simply for an acceptance with a notice of acceptance. The offer very clearly read, upon acceptance and payment of the proposal for settlement, will dismiss the lawsuit. So,
well, I understand that, parties always contemplate that there's going to be performance when they get a promise to perform. They contemplate that ultimately there will be performance, but that doesn't mean that every contract is a unilateral contract.
Well, my point was, and I'll make it simpler, under the law of contracts, there was clearly no performance. That was a mirror image. And therefore, under the law of contracts, there was clearly no settlement agreement. settlement agreements are governed by the law of contracts. That's
Well, but
Robbie
here,
versus City of Miami.
yeah, but Mr. Eaton, this is a great discussion in a vacuum. But here you do have a statute, right? I mean, you don't dispute that we're operating under the offer of judgment statute, and that statute alters a little bit these principles that we're discussing in a vacuum. How do you respond to Ms. Gooden's argument that under the statute, there really isn't anything on the face of the statute to require that Suarez Trucking do anything more to accept the offer? What's your answer to that?
I don't dispute that once suit was filed and then the offer to settle was made, the statute comes into play. But I think the statute is ambiguous, and that the legislature simply failed to consider the difference between a unilateral contract and a bilateral contract.
What's the ambiguity in the statute?
I think it's easy to read the statute to say, here's my notice of acceptance. I am accepting the unilateral contract as the common law of contracts requires. Now,
But counsel, I don't understand how you just get this idea that somehow the common law of contracts requires a unilateral contract. I mean, that depends to a large extent on the way the offer is framed, what the offer is. Now, if here, the way the offer is framed is dictated by this statute. But that's okay. That's your client chose to operate under that statute. Again, there's nothing that requires them to operate under this statute. They could settle outside the statute. They don't get the benefit of the statute if they do that. But if they want the benefit of the statute, it seems like they've got to accept the framework established by the statute. What am I missing?
well, there's no question but that the statute, the way Ms. Gooden wants you to read it, overturns and turns upside down nearly 100 years of contract law in this state. That's a pretty drastic way to read the legislative intent. And it's for that reason that I've relied on this court's decisions in Carlisle and Kitchen, which say, when we look at a statute, before we're going to say it overturns the common law, it has to be clear, unambiguous, and what's the three?
But counsel,
I don't follow how this is overturning the common law. Now we do know that in terms of the attorney's fee aspect of it, it does that is against the common law. That's a change in the common law. But you're not arguing against that. It just seems to me that the common law always has had, the common law for a while now has had bilateral contracts. And I don't understand how the legislature channeling this into the form of a bilateral contract overturns the common law. That's a category that's in the common law.
Well, to be frank with you, I don't think the legislature understood what it was doing. And
we know what they said. We can't delve into their understanding. We just got to look at what they said.
I understand what they said, but I think that what they said can reasonably be read to mean I am accepting this contract by performing it as the law of contracts required. I am accepting. Here's the notice. Here's the check made payable to the plaintiff. It's done. Everybody's happy.
I'm going to stop here. I was got another question that changes this a little bit, and then I'll stop. Or that focuses on a little different aspect of this. Let me ask you this, counsel. Forget about how all this happened. This is a hypothetical. Say that this check was made out to the plaintiff and was sent to the plaintiff's lawyer. What would have happened to that check? How would the plaintiff's lawyer have handled that check? Could he give it to? Could the plaintiff's lawyer give it to the plaintiff and say, "Here, got you $500,000.
Now, you know, there's a lien and they might come after you for that, but here, take it, you cash it, and we'll worry about the lien later. Would the law have done that?
I don't think that the fact that there was a lien in an undeterminable amount has a thing to do with the contract formation question.
I understand I appreciate that. And again, I'm much obliged to you for giving us your views on that, but I'd appreciate if you'd answer my question. I'd be more obliged if you'd answer my question.
Well, the check would be put in the attorney's trust account because there's a lien on it. And that's to be negotiated with the workers' comp carrier.
Okay, if that's the case, counsel, I understand how the rights of your client were in any respect materially affected by the way this check was made out when it was sent the first time.
The answer to that question is when you put the workers' comp carrier on a $500,000 check, when you may be able to negotiate a $200,000 payment to clear the lien, you have given the workers' comp carrier enormous leverage in the negotiation process. It can simply refuse to endorse the check.
I don't understand that because they got the leverage anyway under the scenario you outlined. If they've got to agree or it goes before a court before the money gets dispersed. Isn't that correct?
Yes.
Okay. So they've got that leverage. I don't understand how what's on the check is any more than just an immaterial circumstance.
Because under the law of contracts, it was not a mirror image acceptance of the proposal. That's the answer. I continue to think that the existence of that lien is irrelevant to the question of whether a contract was formed under the law of contracts. And I don't know how else to answer your question, but that let me get
counsel, are you finished answering the Chief's question? Because I just wanted to ask you something.
Could you speak
are you finished answering the Chief's question?
Yes. Okay.
So let's assume that there was a contract. Could you address the breach question? Let's assume there was a contract. I'm assuming your position would be that even if there was a contract, it was breached.
The position of the parties in their arguments below was the plaintiff said no contract. The defendant said, oh, we got a contract. That's all that happened below, and the trial court ruled that there was no contract. That when we came up through the second district, that was an argument, but the trucking company also argued that, okay, there's a contract, but maybe we breached it when we didn't comply with the terms of the proposal. And therefore, the remedy is to enter judgment on this contract that we breached in the amount of $500,000. In other words, although we breached the contract, give us the benefit of the contract, which doesn't make any logical sense to me. And our response, which was a reply to their argument, was no, 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 no. If you breached the contract, if there was a contract, as you say, and if you breached that contract by failing to perform with a mirror image of the proposal, then we are relieved of our obligation to dismiss the lawsuit. That's all we promised in this so-called bilateral contract. We promised that if you accepted and sent us a check in an amount of $500,000 with payment to the plaintiff, then we will dismiss the lawsuit. The law is perfectly clear and has been settled for a long time. And I quoted this court's decision in the Hospital Mortgage Group case, 1982, which says where a party breaches a contract, the other party is relieved of his obligation to perform his part of the contract. That's black letter Hornbook law. So once we didn't get the check that we had proposed to get, if there was a contract, a bilateral contract rather than a unilateral contract, they breached it. Our only obligation on the other side of that bilateral contract was to dismiss the lawsuit. We're relieved of that obligation by the defendant's breach. And
So I don't want to put words in your mouth, but I mean, does that make this kind of if you're right about that, then this whole thing is kind of an academic, this whole question about whether there was acceptance or not is, and under Chief Justice Kennedy's reading of what the offer was, that kind of takes the 768 completely out of the equation, because, one way to read this is that you made an offer that invited a promise and response. So you don't even have to worry about the statute, but you're still left with the breach question. And if you're right about both the breach and the remedy issue, then we're just sending it back just so that the court can refuse to enforce the contract for a different reason than the one that it gave.
well, I have always thought that Ms. Gooden's argument, with all due respect to her, and I do respect her, she's a very good lawyer, was sort of a Rube Goldberg contraption, which said, okay, we got a bilateral agreement in which we promised to fulfill your terms, which is send me a check for $500,000, and your only obligation is to dismiss the lawsuit. But they're saying I got to dismiss the lawsuit even though they didn't comply with our proposal, and we've got to pay them $500,000 judgment. They want the benefit of a contract that they breached, and I think that's the simple answer to this entire problem before the court, how to interpret 768-79. Certainly the statute, the rule could use a little tweaking to support my construction of the statute, but I don't think it's illogical to say, okay, I'll take Ms. Good's argument that there was an argument because we filed a mere notice of acceptance, but you breached the contract. You didn't comply with the terms of what you promised to do under this bilateral contract. And for that reason, the plaintiff is relieved of his obligation to dismiss the lawsuit. Case over. I have never thought that the court needed to get into the thicket of trying to figure out what the legislature intended when it wrote this statute. Now, the statute works perfectly well under my version of it in a case where a defendant makes a proposal for settlement, because requires an exchange of promises. But under an invitation to form a unilateral contract where performance is required, the statute purports to overturn 100 years of contract law in this state. And I don't believe this court is ready to do that. The simplest way to dispose of this case is to say, okay, we accept argumentatively that there was a contract, but if there was a contract, it was breached and the plaintiff didn't have to dismiss the lawsuit. No more questions. I've been arguing cases in this court for 45 years. This will be my last appearance before the court. I'm hanging up my tile and passing the torch to my younger compatriots. It has been an honor and a privilege to practice before this court, and I've enjoyed every minute of it. Thank you very much.
Well, thank you, Mr. Eaton. We wish you well in retirement, and I appreciate your service to the bar and your service to your clients. But we'll now go to rebuttal from opposing counsel.
Thank you,
Not
sir.
on that point, but on the case.
So with regards to, there was just an argument that this argument about breach somehow sprung up during the appeal in the second DCA, and that is not the case. If you look at the transcript, which is found in the record on 812 through 867, the trial attorney for Suarez Trucking specifically made this argument that any breach did not go to formation. It just went to, the check did not go to formation. It just went to breach. And if you take Mr. Eaton's argument, you have to ignore several cases specifically on the PFS statute, specifically Andre versus Myers and Abbott and Purdy. And in both of those cases, it says that the remedy, again, is by entering judgment. That is how you enforce a proposal for settlement in this context. There's no requirement under the statute that a party has to have the ability to pay a proposal for settlement that it accepts. And
Counsel,
so that
did the defense tender a check that was payable only to the plaintiff after the other one was rejected?
no, they offered to have it reissued, and the plaintiff's attorney at that point said, no way, it's too late.
Was that still within 10 days of the acceptance?
I'm actually not sure. It was all right. It was a really tight time frame. I'm just not sure if it was in the 10 days or not.
Thank you.
The PFS statute does not work under Mr. Eaton's framework, and here's why. Because the entire purpose of proposals for settlement is to reduce litigation and settle cases. If you accept Souter's interpretation of this statute, you're actually going to be doing the opposite. Parties are going to be litigating whether or not there was an acceptance, just like they did in this case. There's going to be more litigation, and judicial labor is not going to end. And for that reason alone, we ask this court to reverse and remand for entry of final judgment for $500,000 against my client, and also to approve the conflict cases. And thank you everyone for your time.
All right. Well, we thank you both for your arguments in this case today. And again, Mr. Eaton, we wish you the very best in your retirement. And that will now conclude this session of the Florida Supreme Court.